Your Honor, he began, voice smooth, every syllable designed to be quoted. Before we proceed, the defense moves that you, Judge Rowan, recuse yourself from this matter. The word recuse hung in the air like a struck bell. Richard Halbrook didn't blink. He held the pause, an extra beat. Just long enough for the gallery to inhale. Just long enough for a camera light to flare red. The performance gleamed at the edges, the precise angle of his shoulders toward the press, the pocket square, adjusted at the exact half-second that headlines are born. Judge Celeste Rowan sat very still. Golden rim light traced her cheek and the edge of her robe. The bench looked carved from silence. Only her eyelids shifted. Half a millimeter, a brief narrowing, then gone. A thumb settled on the gavel as if to confirm its weight. At the defense table, billionaire Grant Whitmore smoothed a cufflink that didn't need smoothing. The gesture said, "I belong above this." Across the aisle, Prosecutor Samuel Briggs noticed. Not the brand, the entitlement. His gaze flicked from cufflink to face, reading what power expects when it walks into a courtroom. Rowan's voice was even. "On what basis, Mr. Halbrook?" "On the basis of appearance," Halbrook said, turning slightly, just enough for the microphones to taste the consonants. Justice must not only be fair, it must appear fair. Your record, as widely discussed, reflects a pattern of severity toward defendants of means. My client believes the perception alone threatens his right to an impartial hearing. A murmur rippled. Whitmore's smile was small, charitable, camera-ready. Briggs spoke without theatrics. "Perception isn't proof, counsel. It's theater." Halbrook half smiled as if he'd written the line already. "Then let the audience see a scene." He nodded to the bailiff, who passed a tablet to the clerk. A still frame bloomed on the side monitor. Rowan, captured mid-smile, shaking hands with a community advocate after a prior sentencing review. The advocate, a black woman from a youth program, looked grateful, almost radiant. Halbrook kept his tone low, intimate. This is what the public sees, an alignment, a warmth reserved for certain groups, an appearance of bias. Rowan looked at the frozen smile. The micro-reaction returned, tiny as dust, a held breath released through the nose, then only calm. "I recall that day," she said. "Everyone was thanked. Counsel, victims, advocates. Equally." A beat. "Do you have anything beyond a photograph?" Halbrook lifted his chin. The light found his profile, clean, deliberate. "Sometimes, Your Honor, one picture is worth 1,000 motions." "And sometimes," Rowan said, "it's worth exactly one. Denial." A smothered laugh bubbled in the gallery. Halbrook's eyes slid, just for a flicker, to a lens in the third row, as if checking the line had landed where it needed to land. Outside the role, inside the strategy. Briggs stepped forward. "Your Honor, the state objects to litigating by optics. The standard is evidence. If counsel has facts, he should proffer them. If he has headlines, he should keep them." Rowan lifted a hand. "Objection noted." She turned to the clerk. "Ms. Johnson, mark defense motion to recuse. Pending proffer." "Yes, Your Honor," Maya said, fingers already in motion. Rowan faced Halbrook again. "You will submit the factual basis in writing." Halbrook spread his palms, a gracious host in a hostile room. "We will." "We'll hear it," Rowan continued, "together with the state's preliminary evidentiary matters, recusal, and preliminary evidence in one session. The court proceeds on law, not buzz." The gavel touched wood once. Not loud. Final. Whitmore leaned toward Holbrook. The cufflink caught light, a tiny sun on an expensive horizon. Briggs watched the reflection fade. Power hates equal weather, he thought, though he didn't say a word. From the corridor came the distant thrum of generators and the staccato pop of camera shutters. Reporters were already writing the story they came to find. Someone in the back whispered, "She's staying." Another answered, "Unless the clip spreads." Holbrook cleared his throat with the softness of a man who knows where the microphones are. "Your Honor, the community has questions. The appearance will not direct procedure," Rowan said, cutting in clean, neither sharp nor soft. "File your proffer. We'll let facts speak." Holbrook inclined his head. The actor bowed to the script. Rowan's gaze moved once more to the frozen frame on the monitor. The room could have missed it. The slightest tightening at the corner of her mouth, as if measuring not the picture, but the intent behind it. Then she looked away, and the bench was stone again. Outside, the first push alerts hit phones at once. Bias allegation against judge. Inside, the temperature dropped a degree. The message, unspoken yet unmistakable, filled the space between wood and marble. Power always mistakes scrutiny for bias, and the storm, having been invited in, took its seat. The monitor went dark. The room did not. Rowan aligned a single page on the bench. Small motion, steady message. "Proceed, Mr. Holbrook." He stepped to the lectern like a man walking onto a familiar stage. Voice warm, edges polished. "Your Honor, this is not an attack. It is a safeguard. The appearance of partiality alone can erode public trust. We allege no animus. We allege perception. A reasonable observer, seeing outcomes and public displays of warmth toward certain advocates, could doubt impartiality here. If the court steps aside, trust steps back in." While he spoke, Grant Whitmore made his own argument without words. He cracked his leather folio open just enough for the aisle camera to catch the Whitmore Foundation crest on thick paper beneath. Then he rotated his wristwatch, face gleaming toward the press, set it on the table as if it were a metronome for power. Across the gallery, a foundation aide glanced down, phones lit like dominoes. Briggs rose without polish. "The state objects to swapping evidence for optics. Patterns must be proven, not curated. The defense clipped a smile and calls it a record. Perception without proof is theater, not law." Holbrook angled one shoulder toward the mics, but kept his eyes on Rowan. "We speak of trust, Mr. Briggs." "And I speak of truth," Briggs said. Rowan's gaze moved evenly between them. "Grounds, Mr. Holbrook, briefly." "Media reports of disproportionate severity in white-collar matters. Public camaraderie with rehabilitation advocates tied to low-income defendants. And the climate surrounding philanthropy and influence in this case," Briggs cut in. "Counsel is laundering headlines as findings." "One at a time," Rowan said. "Not sharp, precise." "Do you contend I have a personal interest in the outcome?" "No, Your Honor." "Have I met your client privately to discuss his case?" "No." "Any financial tie, direct or indirect, between me and his foundation?" "No." "Then your motion rests on optics and a claim pattern?" "File the pattern. Cases, dates, dispositions, like circumstances. The clerk will set a time." Maya's pen moved. "Yes, Your Honor." Holbrook dipped his head, then laid a card with care. "One further point. In comparable circumstances, the Administrative Review Panel has been convened by direction of the Chief Judge to evaluate appearance of impropriety within 24 hours. Last spring, a high-profile matter was reassigned after such a review, not for actual bias, but to preserve confidence. We are prepared to request that review. The name didn't need saying. Hayes lived in the example. Briggs squared up. The standard for recusal is not unease. It is informed doubt. So far, we have a still photo and a press machine. The panel you reference acts on facts, not choreography. Rowan's thumb touched the gavel once. A small sound. A measure. Noise grows loudest when truth stands quiet, she said, almost to the wood, then to the room. This court will not chase microphones. It will receive filings. Here is the order. She spoke it clean. Defense motion to recuse. Proffer due by close of business tomorrow with comparators attached. State's preliminary evidentiary proffer. Same deadline. Any motion in limine. File contemporaneously. Hearing on both matters together. 2 days hence, 9 a.m. sharp. Her eyes met Holbrook's. This court will hear facts, not feelings. He gave a gracious half-bow, the actor nodding to the script. Rowan glanced once at the black screen where her smile had been trapped in amber. A breath held, let go through the nose, the micro-tell, and then stone again. Anything further that cannot wait on paper? Silence held. Very well. We are adjourned until the scheduled hearing. The gavel found the block, soft and final. Chairs scraped, folders shut. Whitmore slid the folio closed, covering the crest, then stood without looking back, as if rooms remembered him. The hallway swallowed them in light and noise. Mix rose like reeds in current. Mr. Halbrook, do you think she's unfit to hear this case? He offered the precise sympathy the moment required. We'll see. The line flew. Screens blinked. Headlines sharpened. Briggs didn't chase the microphones. He stepped aside near the clerk's desk where Maya was packing files. You okay? She asked. I'm fine, he said, then didn't move. The leather handle in his hand had worn smooth over years. My dad used to take the late shift at the plant when a VIP toured. They polished the floors and hid the leaks. Said it kept confidence up. He almost smiled. Leaks always came back. Maya studied him. Truth has a way. Yeah. He looked toward the doors where cameras waited. And noise has a budget. She closed the last folder. You'll have your proffer in tonight? Before midnight. He tapped the brief. Facts don't trend, but they stick. They started toward the glare. Behind them, through the courtroom doors, the bench sat quiet. The air settled, as if the building itself had chosen sides. Not with a person, but with a process. The courtroom lights were cooler that morning, the kind that made wood look like stone. Rowan adjusted her notes. Mr. Briggs, he rose. Timeline of communication, Your Honor. Maya tapped the monitor alive. A clean log filled the screen. No headlines, no names, just time, sender, and tone markers. Briggs read, steady. March 10th, 0912. Meeting request from Mr. Whitmore's aide to Procurement Officer Lane. Subject line, checking comfort level before confirmation. He paused. 0948. Follow up. Make sure Lane's steady before award day. 10:05. Whitmore reply, ease him through Sunday. You know how he spooks. A soft murmur spread. The phrase didn't sound criminal, but it smelled of control. Halbrook rose. Motion in limine, Your Honor. Exclude these texts. The language, steady, ease, Spook is ambiguous and in flames in this climate. Rowan's gaze moved to Maya. Chain of custody? Certified, Maya said. Extracted directly from Foundation servers. Briggs. The defense asks for ambiguity where pattern gives meaning. Same sender? Same weekend? Same target. Halbrook kept the tone smooth. In business, we ease vendors, we steady partners, nothing sinister, Briggs replied. And yet, the only nervous man in these messages was a government officer with a vote. Halbrook folded his hands. The court must weigh probative value against prejudice. This is gasoline, Your Honor. Rowan's eyes rested on him. Gasoline isn't prejudice, it's potential energy. The match is intent. A few heads turned at that. She gestured to Maya. Continue the log. Maya scrolled. New entries glowed. 10:20, Officer Lane. No private meetings, keep written record. 10:32, aid to Whitmore. Understood. We'll handle through event night. Briggs added. Lane later reported uninvited calls from unknown numbers. Same phrasing, same weekend. The gallery grew still. Lane wasn't just a name anymore. Someone had leaned on him quietly. Halbrook lifted his motion again. Your Honor, the defense renews its request to sanitize any references that suggest duress. The term spooks is slang, not threat. Rowan tapped the gavel once, gentle. Threat lies in repetition. Context gives it teeth. A clerk, not Maya, entered and placed a sealed envelope on the bench. Administrative seal. Rowan's eyes flicked to it. 1 second. 2. She slipped it under a notepad. Halbrook saw it. He didn't need to ask. He knew the crest. Administrative Review Panel. The shadow of Chief Judge Hayes. He went for tone, not content. Your Honor, appearances have already drawn administrative curiosity. The panel may... Rowan cut him off softly. The panel will receive filings when I'm finished hearing evidence, not before. She looked back to the screen. Mr. Briggs, context for the phrase, ease him through Sunday. Briggs read. It refers to a donor event. Mr. Whitmore's aide requested table placement next to procurement officers. The witness declined. Any further communication? Rowan asked. One more, Briggs said. Sunday night, 10:42. Aide to Whitmore. Lane still stiff. We'll try after dessert. Someone exhaled in disbelief. The sound felt loud. Halbrook cleared his throat. Intent can't be imported into casual chatter. We are decoding tone, not crime. Intent speaks, Rowan said, in repetition and timing. She looked down the list again, then ruled. The defense motion is denied as to the messaging chain March 10th through 12th. The court finds probative value substantial, prejudice manageable. The state will present the full thread, not isolated phrases. References to unrelated commentary will be redacted. The gavel touched once. Maya typed, rhythm precise. Briggs gave a quick nod. Understood. Whitmore leaned forward, whispering to Halbrook. The microphone caught only fragments. Panel. Pressure. Not yet. Rowan noticed but said nothing. Halbrook straightened. For the record, the defense reserves argument on interpretation at trial. Granted, Rowan said, argue meaning later. Today we admit fact. The monitor dimmed. Silence filled the vacuum. In that quiet, the envelope under Rowan's pad seemed heavier. The presence of Hayes was felt the way thunder is, still beyond the hills, but certain. Briggs closed his brief. His face stayed calm, but his hand flexed once against the leather. Your Honor, the state rests its evidentiary offer for today. Rowan nodded. Then the record will reflect Motion in limine denied in part, granted in part. The messaging chain is admitted. Hearing adjourned until joint session. The gavel fell with the weight of reason. Counsel began to pack up. As the reporters pushed forward, Maya whispered, "That witness, Lane, he's asked for security clearance to park inside." Briggs glanced over. "He'll need it." A pause. "He's not built for this kind of spotlight." "Neither is fairness," Maya said quietly. Briggs smiled faintly. "Then we'll steady it." Outside, the first microphones waited. Inside, the bench glowed in the last slant of amber light. "Truth isn't polite. It's admissible. Have you ever seen fairness mistaken for bias? Stories like this remind us why respect matters. Only on JusticeSoul." The folder Halbrook set down looked like money had learned to whisper. "Defense Exhibit C," he said. "The Whitmore Foundation's $1 million gift to this court's community youth initiative. We submit it to show how perception cuts both ways. Proximity breeds doubts." The gallery stirred. Rowan cut through it. "Indebtedness, counsel?" "Familiarity," Halbrook corrected. Briggs rose. "Then let's read the fine print." Maya brought the email thread to the monitor. Subject line, coordination terms. Clean font. Calm poison. Briggs read, "Donation conditional upon annual donor recognition meeting with select administrative judges and staff for continued partnership." A spark ran through the room. "Objection," Halbrook said. "Standard philanthropic language. Community engagement isn't privilege." "Authentication?" Rowan asked. "Verified," Briggs answered. "There's more." Maya scrolled. The next line appeared chopped. "We appreciate your mutual under—" Halbrook noted the truncation. "Convenient. From our servers," Briggs said, ignoring him. The full line reads, "We appreciate your mutual understanding that these recognitions ensure smoother coordination and access for our representatives." The word hung there like a gloved hand on a doorknob. Rowan's gaze stayed on the screen. "That word does heavy lifting, counsel." At the defense table, Grant Whitmore's jaw ticked once. He leaned to Halbrook, whispering quickly. A brief intake of breath from the lawyer said enough. He hadn't known all of it. The performance returned to Whitmore's face, tidy smile, measured calm, but the knuckles under the table pressed white against leather. Briggs kept going. "Same date range as the ease him through Sunday texts? Same target. Procurement Officer Lane. Same weekend donor event." Halbrook stepped back into stride. "Your Honor, the defense renews its request to limit donor correspondence. None of this involves judicial decision-making. It is administrative, prejudicial, irrelevant at trial." Rowan weighed, then spoke like a scale settling. "We are still at admissibility. Charity turns dark when it comes with a schedule. The thread stays, for context, not condemnation." Maya typed. The rhythm steadied the room. A deputy clerk brought a cream envelope from the administrative review panel. Rowan read the note from Hayes, an informal consultation request. She folded it. "Declined until these hearings conclude. Inform the Chief Judge this bench does not adjourn to whispers." Across counsel tables, Briggs gave the smallest nod, gratitude without applause. Halbrook watched the door a beat too long, recalculating. "Very well," Halbrook said, pivoting. "If the emails remain, the defense demands a Rule 104 hearing on the word access. We will subpoena the relevant staff." Briggs didn't hesitate. "The state welcomes it, and we will move to compel call logs and depose the aide who wrote the texts." Rowan nodded once. "Set the 104 hearing. Narrow questions to meaning and practice. No grandstanding. Maya was already moving. Your Honor, cross-verify on the distribution list? Rowan glanced over. Maya had pulled up a second panel. Recipient headers, DKIM pass stamps, time sync. This template email hit 13 judges, she said before anyone asked. No personal addressing. Bulk send. Access language identical across all recipients. Thank you, Rowan said. It wasn't rote, it was approval. Halbrook opened his palm as if to show there was nothing up his sleeve. Then our proximity argument narrows, but it does not vanish. The word access still threatens impartial appearance. Appearance isn't a verdict, Rowan said. It's an angle. Facts flatten angles. She turned to Briggs. Any further offer of proof today? One note, he said. Officer Lane has requested interior parking and an escort. The state asks for a brief order facilitating that. Rowan's eyes flicked to Maya. The clerk already had a form half-filled. Granted. Witness security matters, counsel will coordinate with the bailiff. In the first row, Whitmore's smile cooled a degree. He stared at Briggs with the sort of patience that thinks time is a resource you can buy wholesale. Rowan saw it. Mr. Whitmore, this is not a salon. It is a court. Keep your expressions neutral. The billionaire's eyes slid away, then back, the tiniest challenge retreating under protocol. Halbrook lifted his chin. For the record, defense reserves all objections and appellate issues relating to donor evidence and witness security characterization. Preserved, Rowan said, and noted without editorial. She summarized for the record. The donor email chain is admitted with context. The 104 hearing is set. Witness security is granted. So ordered. Maya logged the rulings and sent the security email. Counsel began to close folders. Whitmore closed his a fraction too hard, then smoothed the cover with a flat palm, as if pressing wrinkles from a story. Halbrook turned toward the gallery and lowered his voice to that careful register microphones crave. Perception is power. The line flew where he wanted it to. But inside the room, the only power that mattered had just been written into the record. The room adjusted itself before anyone spoke. 2 rows back, Chief Judge Roland Hayes sat like a boundary line. No entourage, no comment. All gravity. Rowan glanced his way for half a second. Mr. Briggs! Briggs rose, presenting data from the last 12 months. Like cases, like rulings, he said, showing consistent bail and sentencing. He then preempted Halbrook's next move with a control study. Confidence only drops when the polling question is primed with the word wealthy. Otherwise, the perception vanishes. Rowan inclined her head, crisp. Efficient. Halbrook presented his own chart, a decline in public confidence. Briggs immediately challenged the polling data. Maya found the flaw. The prompt wasn't neutral. It used headline defendants. A different prime, same nudge, Briggs countered. Rowan cut through it. Show me the cases behind your perception series, Mr. Halbrook. It's not case-based. Then it's not landscape, she said. Halbrook presented a second chart, showing an uptick in custody sentences. Briggs went to counter it and froze. He and Maya searched their files. The key cooperation letters were missing. For a beat, the state was silent. In that silence, Whitmore, not Halbrook, gave a silent order to his aide with a single tap on a phone. The choreography was his. Briggs recovered. Your Honor, 3 cooperation letters are missing. We will supplement. But even without them, 2 cases in that quarter involve obstruction. Citations? Rowan asked. Filed by noon, he said. He swallowed the rest of the sentence and chose a cleaner one. Today I can show cause in one of them. The other two will walk in on paper. Halbrook's eyes said he'd enjoyed that stumble. He didn't gloat, he pivoted. And while the state searches for its context, the public sees the curve. Data lies louder than men when context is cut out, Rowan said, and the gallery felt the wood take the line. Briggs stepped into the opening. Then let's put context back in sight. He pointed to S1 again. 2 defendants, same statute, same loss amount. A cooperated early, community service and restitution. B obstructed, custody. Income brackets reversed from the story counsel is selling. That's landscape, not lens. Rowan nodded once. Place those into the record. Across the aisle, the aide's phone lit. He didn't raise it. He rotated it flat on his knee, waiting for a cue that didn't come from Holbrook. It came from Whitmore's fingertip. A tiny, downward press. Send. Holbrook continued, voice mild, hand open. Respectfully, Your Honor. Whether by wealth or fame, the public perceives differential pressure. We can either resist that perception or correct it. Our position is simply... Just then, Maya's console flashed a news alert. She showed Briggs a live article using Holbrook's misleading chart, time stamped now. Briggs addressed the court. Your Honor, the defense is litigating by leak, in real time. He held up the screen. This isn't speculation. It's a timestamp. Holbrook's denial was flat. I cannot control the press. Rowan pinned Holbrook with one sustained second. Are you handing incomplete materials to the press during a hearing? I cannot control what the public chooses to publish. You can control what you hand them, Rowan said. This courtroom is not your press room. The sentence landed flat and heavy. Hayes did not move, and somehow that made it colder. Briggs pressed his advantage, not loud, just edged. We further request the record reflect that Exhibit D4 was superseded in court and that reliance on its earlier form is misleading. Noted, Rowan said. Any party who prosecutes by leak invites sanction. She let the warning sit where everyone could feel it. Whitmore relaxed in his chair just a little, as if the point of the leak had never been court persuasion at all. It was market movement. Optics as asset. He glanced at Holbrook, not deferential, not hostile, measuring tolerance like a share price. For once, the lawyer looked like the passenger. Rowan returned to business. Mr. Briggs, finish your comparators. He did. Tighter now, smarter for the bruise. Last point. We've submitted 8 cases where wealth did not buy advantage and 2 where cooperation did. The rule is not who you are, it's what you do. Rowan looked from one set of boards to the other, then to the room that had tried to become a studio. We finish on records. Reset your exhibits for 9 a.m. tomorrow. Any supplements must be filed by noon today. Ms. Johnson, note the deadlines. Yes, Your Honor, Maya said, already typing. She added one more line of her own. Check missing letters. Call AUSA on second case. Pull docket notes. If the machine of fairness had a heartbeat, it sounded like that. As counsel packed, her phone buzzed again. Second alert, second outlet, same chart, same missing context. She turned the screen so Briggs could see. He gave a quick, tight nod. Seen. Outside, the article had already gone live. Inside, the law had already said what it would say. The difference, as always, was who could hear it, and who wanted to. The gavel didn't need to be loud. The point was already made. Detective Camilla Reyes took the stand the way she wrote her reports. Square, spare, nothing hanging loose. Briggs stood a few feet from the witness box. Detective, chain of custody for the message thread marked S12. Collected from the Whitmore Foundation archive via subpoena, she said. IT custodian present. Hash values verified at intake and at transfer to evidence. Matches are exact. Gaps? None. Contact with Procurement Officer Lane? Twice in person, 5 times by phone, all recorded in a case log. He reported uninvited calls during the donor weekend. We traced 2 to prepaid devices bought with cash. Briggs nodded once. Your Honor, the state moves S12 into evidence. Halbrook rose. Objection, foundation, incomplete as to the prepaid devices. Authenticity and attribution are speculative. Reyes didn't wait for a cue. Device 1 pinged a tower 2 blocks from the donor venue at the exact time the aide wrote after dessert. Device 2 pinged within a minute of the follow-up text, he still needs easing. Both towers overlapped the valet lot where Mr. Whitmore's staff cars were staged. Rowan looked over her glasses. Attribution? We can't name the caller, Reyes said, but the calls and texts moved in the same minute-by-minute rhythm. Objection overruled, Rowan said. S12 is admitted. The jury will hear limits at trial. I hear chain today. Briggs stepped back. Detective, summarize the timeline as you saw it. Friday morning, meeting request for Lane. Friday noon, Lane declines private contact. Saturday afternoon, prepaid calls start. Sunday, donor event. Aide messages about table placement and after dessert. Sunday night, final nudge. He spooks. Monday, Lane emails. I am not comfortable with this. The words didn't shout. They fit together. Halbrook approached for cross with his courtroom smile, set at half power. Good morning, Detective. Good morning. You're a career officer. You've seen negotiations in every costume they come in? Yes. In business, people ease partners into agreements. In politics, they steady stakeholders. You read color into grayscale, don't you? I read rhythm, Reyes said, and whether it speeds up when a door is supposed to be closed. He paced, easy. This rhythm of yours? Science? Pattern recognition, she said. The kind juries accept when it comes with times and places. He turned a page he'd memorized hours ago. You mentioned 2 prepaid phones. Any video of the buyers? No. Fingerprints? No. Names on the accounts? They're prepaid. So you have timing, towers, and a hunch. He shifted tone, aiming for paper cuts, firing off questions about tamper seals, ink color, a corrected typo in her log. Reyes answered each without pause. My correction is in the audit trail, she finished, shutting down his entire line of attack. He stepped 1 pace closer to the witness box rail. Detective, you dislike Mr. Whitmore's wealth, don't you? Briggs. Objection. Rowan. Sustained. Halbrook tried again from the side. You think donors buy access? Briggs. Objection. Rowan's gavel touched wood once. Counsel, we are not litigating her political theory. Move on. Help me with motive, Halbrook asked. What does he gain? Time, Reyes said. Access. A softer no that becomes a maybe. And if the words meant nothing? Then the rhythm is still wrong, she said. Pressure still lines up with dessert. For the first time that morning, Whitmore's jaw set hard enough to show. He looked not at Halbrook, but at Briggs. The look wasn't heat. It was calculation cooling into steel. Confidence cracks quieter than glass. Halbrook went for the technicals again. You destroyed the original phone images after extraction? No. Originals preserved in a write-blocked archive. 2 mirrors created, 1 stored off-site. Your report references Lane's discomfort. That's a feeling, not a fact. It's a statement, Reyes said. It's also how witness tampering starts without saying hello. Speculation. Briggs stepped in, calm-edged. It's experience. And it's why the law draws lines before harm lands. Halbrook lifted a fresh page. Detective, did you ask Lane whether he'd ever met Judge Rowan? Reyes looked at him. He has not. Did anyone tell him the judge wouldn't like back channels? Briggs. Objection. Asked and answered by the record. Sustained, Rowan said. Move on or move off. He tested the rail with his fingertips, then let it go. No further questions. Briggs returned for redirect in 2 moves. Detective, are there gaps in the message chain the defense keeps calling ambiguous? No. Is the chain authentic? Yes. Do the calls and texts align? Yes. Nothing further. Rowan leaned back, eyeline steady. Detective Reyes, you may step down. Reyes left the stand as she came. Square, spare, nothing loose. The evidence stayed where she'd left it, standing. The judge turned to the room. Record will reflect the witness testimony stands and the exhibits remain admitted. Counsel, we reconvene on the motions at 9 tomorrow. Do not try this case on the courthouse steps. She rose. The gavel did not need to be loud. In the corridor, lights gathered like weather. What does fairness look like when power starts to bend the rules? Stay with JusticeSoul, where calm meets consequence. Recess. The hallway met them with a tide of questions. They'll push for a quote, Maya said, low. Law doesn't debate in hallways, Rowan replied, not breaking stride, as her heels clicked a steady rhythm against the stone. Well-suited men guided a cluster of donors on an informal tour. They paused at the courtroom's glass wall, where one said, just loud enough, impartiality must look impartial. Briggs saw it from the security desk. That's not a tour, he told Maya. That's money doing choreography. Good, he said. Lane doesn't owe the steps a show. Maya tilted her head toward the tour. That's not a tour. No, Briggs said. That's money doing choreography. Down the hall, Richard Halbrook appeared with a folder the color of washed bone. He wasn't in a hurry. He didn't need to be. Cameras adjusted themselves around him. Halbrook met Rowan at her chambers, a folder in hand. A matter of professional candor. He revealed the title page, draft, Judicial Ethics Complaint, unfiled. A precaution, he said, should public confidence continue to suffer. Rowan didn't look at the text, only at him. Filed complaints are arguments. Drafts are threats. Perception is the client we all serve, he countered. In my courtroom, she said, the client is law. From the stairwell, a soft echo. Applause. No, something else. Phones pinging in sequence. The tour had found a headline to pass around. Halbrook lifted a second page, just enough for the nearest lens to taste the edge. I will, of course, send this to opposing counsel before any formal step. Briggs reached for the document. Then start with me. Halbrook let him have it. Briefly, their fingers touched the same corner. Contact without concession. Rowan looked to Maya. Scan it. Log it. Then give it the same respect it gives the docket. Maya understood. Record receipt. Note unfiled status. Copy to both sides. Halbrook inclined his head, absorbing the demotion. We are all balancing duties, Judge, to clients. to courts, to the public mood." Rowan's reply was quiet. "The loudest defense is guilt rehearsing." For a heartbeat, Halbrook's eyes cooled a single degree. Then the code of courtesy slid back into place. "We disagree," he said softly. Briggs stepped forward. "Then disagree on paper. But if your donors think this hallway is a stage, we'll get an order clearing it." Halbrook looked past him to the tour, then down to the ethics draft in Briggs's hand. The calculation was quick, then gone. "I'll advise my client to respect the building." "Respect isn't a route," Briggs said. "It's a rule." A runner from administration brought a request from Hayes for an off-the-record meeting. Rowan's reply was firm. "I'll confer when the record is complete, not before." Just then, Maya's phone buzzed. "The tour wants a second slot." "Deny it," Rowan said without pausing. "Court operations take precedence." Maya's fingers were already moving. The corridor shifted. You could feel the mood change when a plan hits a wall. Halbrook checked his watch, then the cameras. "If there's nothing further, Your Honor, I'll prepare for the 104 hearing." Rowan held the door to chambers, then let it close an inch. "Filed or not, the trial continues." He accepted the line without blinking. "As it should." He moved off, collected by microphones. The tour began to dissolve, but not without leaving its perfume. Questions spoken as facts, doubts spoken as duty. Maya came up beside Rowan. "You could give them one sentence," she said, not pleading, a professional suggestion. Rowan considered the hallway, the marble, the glass, the waiting eyes. "One sentence becomes a speech," she said. "Speeches become sides. We don't argue here." They waited as the cameras surged and ebbed, as the wind of attention shifted and left little drafts in its wake. A photographer pushed for a shot as the judge turned. The flash went off close, a white blade to the eyes. Rowan didn't blink. The moment fixed itself. Light, wood, steadiness. And the hallway understood what the courtroom already knew. Silence, when it belongs to the law, is not retreat. It is command. Inside, the clock moved. Outside, the story grew teeth. And the trial, on paper, not on marble, went on. When Judge Rowan entered the courtroom, she stopped. Not at the noise, but at the sight. A second chair had been placed beside her bench. Occupied. Chief Judge Roland Hayes sat there in full robe, posture immaculate, smile thin as parchment. "Good morning, Judge Rowan," he said, already at the microphone. "Given the extraordinary public scrutiny of this proceeding, administration has assigned me as co-presiding judge to ensure transparency." The word transparency carried the sound of intrusion. Rowan answered with the smallest nod. "Noted for the record." She took her seat beside him. 2 benches, 1 rule. Maya, at the clerk's desk, felt the temperature drop 5 degrees. Halbrook looked pleased but tried to mask it with concern. "Your Honor, we welcome this administrative oversight. It assures confidence that all parties receive fair review." Briggs didn't smile. "Confidence or company, Mr. Halbrook?" Hayes cleared his throat. "Let's proceed." Rowan tapped her pen once, as if anchoring herself. "The court will now hear argument on the defense motion to recuse, under the standard of a reasonable observer fully informed. Counsel, you may begin." Halbrook rose, voice reverent as a prayer. "Your Honors, recusal isn't about guilt or virtue, it's about appearance. Even perfection cannot self-certify fairness. When headlines question neutrality, the robe must step aside so trust can step forward." Rowan said nothing. Hayes leaned slightly toward her microphone. "Thank you, Mr. Halbrook. Mr. Briggs?" Briggs stood, composed, but charged. "Your Honors, appearance must rest on facts. We provide them." Maya rolled out 2 comparison boards. Simple, exact. "Across 12 months," Briggs said, "Judge Rowan's sentencing and bail rulings mirror those of 4 peer judges in identical cases. Income levels varied from minimum wage to corporate boards, yet bail decisions and sentences remained within the same range. Identical deviations, identical thresholds." He pointed with precision. "No pattern of prejudice, no bias for or against any financial class, just law." Halbrook stepped forward, smiling as if invited. "And yet perception persists, perhaps because the court sometimes speaks beyond law. Statements about dignity, respect, equality. Lofty, yes, but political in tone." Briggs didn't let it stand. "Respect is not politics. It's procedure with manners." A low chuckle rippled, then died under Hayes's glance. Halbrook pivoted. "In that case, perhaps the prosecution should clarify its own impartiality. The state's filings display an unusual vigor in defending Judge Rowan personally. That energy suggests Mr. Briggs is not a neutral officer of the court, but a participant with a stake." Maya froze. That was the move. Halbrook lifted a fresh motion, crisp and white. "Defense requests the prosecutor's withdrawal from this matter on grounds of potential bias. He may now be a witness to events surrounding the alleged pressure campaign, particularly interactions with court staff and the media leaks." The room murmured. Even Hayes tilted slightly, intrigued. Briggs's voice sharpened. "Objection to that motion on every axis. The state isn't a witness. The state is the record. If I were biased, the facts would have folded a long time ago." Halbrook bowed slightly. "Sometimes bias folds too late." Rowan turned her head toward Hayes, calm but cold. "Administrative co-presiding judge, do you intend to hear a recusal motion nested inside a recusal motion?" Hayes smiled without warmth. "Every argument deserves air." "Air," Rowan said, "is not oxygen. We'll start with the original motion. Mr. Briggs, continue." Briggs nodded, jaw tight. "Exhibit S21, a statistical table of every probation variance and bail review. The data shows no disparity based on income. If anything, stricter terms appear in cases of violence, not wealth. The record is math, not mood." Maya passed copies to both judges. Halbrook didn't glance down. His attention was on the cameras perched above the press rail. At that moment, Maya's phone buzzed softly. She read the text, her face stiffening. "Your Honor," she whispered to Rowan, "Local Councilman Evans, the one from yesterday's tour, just issued a statement. He says he's concerned about the atmosphere of intimidation within this courthouse, citing whispers about bias. It's already on 3 networks. Rowan exhaled, almost a laugh, then not quite. "Thank you, Ms. Johnson. We'll add it to the pattern. Perception creating itself." She turned to Halbrook. "You've built a shadow and called it daylight. Present your evidence." Halbrook spread his palms. "Perception is daylight, Your Honor. Once shadowed, trust rarely returns." Briggs countered, voice steady but gaining edge. "Then we will trust procedure, because a judge's defense is procedure itself." He gestured to the data again. 12 months, 4 peers, no deviation by wealth. That's the definition of even-handed. Hayes leaned back, studying both. His tone was courteous, but the undercurrent was knife steel. "Mr. Briggs, Passion is admirable, but perhaps misplaced. The public eye may still see impropriety, regardless of charts. Briggs met him head on. Then the public eye needs glasses, not new judges. The gallery gasped. Even Maya's pen paused. Rowan didn't flinch. "Counsel, remember where you stand?" "Yes, Your Honor," Briggs said. "Right behind the record." Silence thickened. Hayes's jaw tightened, but he said nothing. Rowan looked across the benches. Halbrook poised, Briggs braced, Maya still typing the heartbeat of the moment. Then she spoke into the microphone, voice level as a scale. "Under the standard of a reasonable observer, fully informed, not half-informed, not misinformed, the court finds no evidence of bias, prejudice, or partiality. The statistics confirm procedural consistency. The filings show no personal interest. The record stands." She paused, then turned slightly toward Hayes. "Administrative oversight noted, judicial independence preserved." The sound in the gallery evaporated. Even the reporters stopped typing. "Accordingly," Rowan said, "the defense motion to recuse is—" She raised the gavel, eyes calm, hand steady. "Denied." For a full second, no one breathed. Then the room exhaled all at once. Halbrook lowered his gaze, lips tight, already calculating the next move outside the courtroom. Whitmore leaned back in his chair, the faintest hint of anger cracking through his mask. Maya stopped typing and looked up. The silence after justice always sounded the same, like a verdict that needed no echo. Rowan tapped the gavel once, softly. "This matter is resolved. We proceed on law, not rumor." A flash burst from the press rail, white and sudden. It caught Rowan square in the eyes. She didn't blink. The camera captured something no headline could name. The moment calm became command. And the room, full of people who'd come to witness doubt, realized what they were actually seeing was steadiness surviving the storm. After lunch, a new quiet settled. Rowan took the bench, her gaze landing on a brass placard in the front row. "Reserved." "Mr. Cole," she said, her voice level, "remove that sign." The order traveled the room like a pulse. Cameras tilted. Attorneys stilled. Aides forgot their phones. The bailiff knelt. A soft metallic bite as the first screw turned. Whitmore's face was a mask of indifference, but his jaw betrayed him. Briggs sat straighter. The second screw came loose. The bailiff lifted the placard free. A tiny, bright ring echoed in the silence, the sound of a privilege being unmade. A ripple passed through the gallery. Not applause, understanding. Rowan let the moment sit exactly long enough to be seen. "Seats are first come, first served," she said. "This courtroom recognizes two kinds of status, party and public. Money can rent seats, not stature." She didn't look at Whitmore when she said it. She looked at the wood. The bailiff carried the placard out through the side door. The space it left looked like a thought that didn't belong. Rowan nodded to the clerk's rail. "For today's sessions, counsel will keep the first row clear for witnesses and those with limited mobility. All others, choose any open seat. We proceed." People moved, a quiet reshuffling. Donors slid back. A woman with a cane took the newly open aisle seat. The room found a new, more natural order. Whitmore stared directly at Rowan, his eyes asking the question money always asks when told no. "Are you sure?" Rowan answered the way law answers questions from power. Not with a speech, with a schedule. "We will hear the 104 matter on access language," she said, voice clear. "Then remaining evidentiary issues. Then calendar next steps." Hayes remained in the second chair, hands folded, face, landscape, still. If he disapproved, it didn't show. If he approved, it didn't either. The administrative mountain had learned the altitude of silence. Maya, scanning the room, caught the last small holdouts of habit. Two men lingering at the aisle ends as if the path ahead still belonged to them. The bailiff's presence, unspoken, solved it. They sat. The aisle became a public road again. Briggs leaned close enough for Maya to hear. You'd think wood and brass couldn't change a room. They didn't, Maya said. The order did. A latecomer, no suit, no badge, hesitated at the back. A seat opened in the third row. A donor in a perfect jacket gave a small nod, inviting him forward. He took it. He looked stunned that courtesy worked. Rowan returned to the files, but the room kept holding the picture, the gap where the sign had been, the straightened spine of the gallery, the way light no longer seemed to prefer one row over another. On the Rule 104 hearing, she said, questions will be narrow. We're defining practice, not prosecuting philanthropy. Keep answers in the lane. Halbrook lifted his eyes. He'd lost a plaque and gained an audience. His smile adjusted accordingly. Briggs stood. Understood, Your Honor. Good, Rowan said. Then we proceed on the same rule that has carried us from the first minute to now. She rested the gavel's head on the block without striking. The wooden edge caught the light, gold, thin, exact. A photographer lifted a camera. The flash hesitated, then didn't dare. Rowan spoke into the kind of quiet that belongs to decisions. Equal rules, equal room. The line didn't chase applause. It didn't need to. The room had already rearranged itself to echo it. The bench light held, a narrow sun along the gavel's rim. Somewhere in the hall, a door closed softly, and the building seemed to agree with itself. The session moved on. The story did too. But the sign, absent and present at once, kept working in the back row of every mind. There are places where names step aside, and the only thing that gets a seat is order. The gallery emptied slower than usual, like people leaving a church after the hymn. A donor steadied an elderly man at the aisle. A junior clerk snapped one photo of the bare front bench, then tucked the phone away, almost guilty for wanting proof. Maya met Rowan at the side door. That was bold. No. Required. They stepped into the corridor. Reporters swelled forward, then paused, as if the air itself had learned a new rule. Down the marble steps, Briggs kept pace with the bailiff, files tight to his ribs. An administrative aide intercepted him, smile thin, language sharper this time. Counsel. The chief will be issuing a formal letter of caution. Any further editorial remarks on administration may trigger referral to the Professional Responsibility Panel. Briggs absorbed it. Understood. A beat. Then we'll let the record carry the weight. The aide nodded. Warning delivered. Teeth shone. At the foot of the stairs, cameras turned to Halbrook. Courtesy coat immaculate, the eyes behind it awake again. Mr. Halbrook, thoughts on the sign being removed? He allowed a measured breath. Seating is symbolism. We respect the court's preference. A second mic rose. And the motion? The motion speaks for itself, he said, and added just enough iron to ring. Perception is patient. We'll address our remedies on the record, not on the stairs. A voice cut from the press line. Judge Rowan? Will money ever lose its power? Rowan didn't slow. Only when fairness keeps its price. Heel clicks counted the distance. 1, 2, 3, then softened into carpet and turned into quiet. Respect isn't granted upward. It radiates outward. Behind her, the brass placard lay face down on a clerk's cart, just wood and screws now. In chambers, Maya set the orders on the credenza. Briggs slid the last exhibit into a box labeled Access, 104, and exhaled. Rowan checked the clock. We keep the calendar, law holds. She passed a window and caught it in the corner of her eye. A black SUV idling at the curb, tinted glass, a driver watching the door. Power doesn't go home. It waits. The chamber door settled. The gold along the gavel's rim thinned, then faded with the light. The city kept moving. But for a beat, the courthouse felt like it had taught itself to breathe. If you were in her seat, what would fairness look like? Subscribe to JusticeSoul for more stories where law meets dignity.